everyone. It's 3:30. Let's get started with our meeting. We will begin with request for bill introductions. Does any member of the committee have a bill they'd like to request? Yes, Representative Titus.
Thank you, Mr. Chairman. I would request the introduction of RS 0328 regarding involuntary discharges and transfers from adult care homes. This bill was previously known as Charlie's Law, and it was vetted last year by the Children and Seniors Committee, reviewed by the Judicial Council with a number of due process updates. And so this seemed like a more appropriate committee to review it this year.
Got any questions or objection? We will get that one introduced. Any other members with a request? Okay, from the gallery, I know Nancy Strauss is here. Come on up, Nancy.
Doesn't seem there. It is on. Okay, I'm sorry. I'm Nancy Strauss with Kansas Judicial Council, and I have 4 bills to request today. The first is the first 3 came out of our probate committee. The Uniform Trust Decanting Act is 23 RS 0490. We're requesting a bill to increase some certain dollar amounts within the Kansas probate code, and that is RS 0329. And there is a bill to modify some time requirements that are linked to notice by publication. There's some difficulty meeting deadlines because some newspapers aren't publishing as frequently as maybe they used to. The final bill is from the Judicial Council itself. It's going to be a very short bill that clarifies the Judicial Council's statutory mission.
Nancy, those last 2, what were the RS?
Oh, I'm sorry.
So the time requirements.
The one modifying time requirements is 0330, and the Judicial Council statutory mission bill is 0423.
Very good, Nancy. I know Representative Carmichael wants to ask this question. The Trust Decanting Act, does that involve alcohol or not?
How did you know what I was thinking? That's exactly what I was thinking.
Just very tangential.
Okay. Any questions, committee? Any objections? Okay, we'll get those requested, introduced. Thank you. Nancy. Jeff is up next.
We on? She turned it off. Okay, we'll do this again. Good afternoon, Mr. Chairman. Jeff Weigeman from Steve Kearney and Associates, representing the Kansas County and District Attorneys Association. We would like to introduce 3 bills in your fine committee. The first one is 23 RS 0229, a bill concerning DNA testing of irrelevant evidence. The second, 23 RS 0366, a bill concerning domestic violence definitions and intimate partner relationships. And the third one, 23 RS 0246, a bill concerning statutory speedy trial.
Committee, any questions or objection? Yes, Representative Heiberger.
Why do you want to conduct DNA testing on irrelevant evidence?
We're just trying to make it more efficient. So trying to use our time and resources wisely.
Representative Owens.
Thank you, Mr. Chairman. I thought it was only fair to ask the question. It seems like we've talked about statutory speedy trial before.
Time or 2, I think.
Thank you. We have, but we'd like to talk to you a little bit more about it. So.
Okay, not seeing any objections or serious questions. Those will get admitted as well. Thank you.
Always a pleasure. Thank you.
Any other bill requests? Okay, we'll move on. We have 2 hearings and then a presentation. I will open the hearing on House Bill 2015 and have Natalie give us a brief overview.
Thank you, Mr. Chairman. House Bill 2015 would authorize the designee of an employing agency or entity head to petition the court for an order requiring infectious disease testing. The bill amends KSA 656008. Current law in that statute requires that if a certain employee is exposed to the transmission of bodily fluids from one or more other persons while they're performing their duties, then the head of that employing agency can make application to the court for an order requiring those other persons to be tested for infectious disease. This bill would authorize the designee of the agency head instead of the agency head themselves having to make that request to the court. And I can take any questions.
Any questions? Good. Thank you, Natalie. Proponents, I have one listed, Ed Klump. Welcome back to the committee, Ed.
Thank you, Mr. Chairman, committee members. My name is Ed Klump. I am here on behalf of the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. After that explanation, I feel like I should just say any questions, but I'll give a little bit further information on what the problem is we're trying to fix. What we have encountered is sometimes we have an incident occur where we need to get one of these court orders for the safety and protection of our officers, and the agency head is out of town on training or vacation. And we've had a few courts that said, wait a minute, the statute says only the agency head can make this request. And so we just want to add that provision in there that would allow the agency head to designate another person in their absence to be able to do that. That's the whole thrust of the amendment. You'll see that on page on line 13. There's two other amendments on line 19 and 13, which are revisor amendments, just technical amendments, I believe. So that's the bill, and I'll be glad to answer questions.
Any questions?
I would point you to the last line in my testimony where I suggest that this might be a ripe bill for the consent agenda.
Now we have a question.
Now we have a question. I should have sat down.
Mr. Klump, semi-seriously, there have been bills placed on the consent agenda that were objected to because certain members disfavor the consent agenda and believe that the full House needs an explanation of legislation, an opportunity to ask questions, and then a chance to vote. So just be aware that there's not any guarantee that that plan might work.
I am well aware that there is no guarantee on anything under the dome.
And I'm one of the members who frequently does that, by the way.
Thank you, Ed.
Thank you.
Any other proponents? Do we have any neutral conferees? Any opponents? Not seeing any. I'll close the hearing on House Bill 2015 and open the hearing on House Bill 2017 and have Natalie come back up.
Thank you, Mr. Chairman. House Bill 2017 enacts the Uniform Family Law Arbitration Act. Section 1 names the act, and Section 2 provides the definitions to be used throughout the act. Section 3 provides that this act governs arbitration of family law disputes. The act does not authorize the arbiter to make an award that grants a divorce, annulment, or separate maintenance, terminates parental rights, grants an adoption or guardianship, determines the status of a child in need of care, or determines the existence or non-existence of a parent-child relationship. Section 4 would provide that except as provided in this act and in the Uniform Arbitration Act, the General Act, would govern arbitration. In determining the merits of a family law dispute, an arbiter shall apply the laws of this state. Section 5 provides that an arbitration agreement shall be an assigned record, identify the arbitrator, and identify the family law dispute intended for arbitration. An agreement to arbitrate a child-related dispute that arises after the agreement is made would be unenforceable unless those parties affirm the agreement in record after the dispute arises or the agreement was entered during a family law proceeding and the court approved or incorporated that agreement into the order that's issued. If a party objects to arbitration on the ground that the arbitration agreement is unenforceable or doesn't include a family law dispute, The court shall decide whether the agreement is enforceable or includes that family law dispute. Section 6 provides that a party may initiate arbitration by giving notice to arbitrate in a manner specified in the agreement or under Article 4 of Chapter 5. Again, that's the General Uniform Arbitration Act. Section 7 provides that a motion for judicial relief has to be made to the court in which the proceeding is pending, or if there is no proceeding pending, then the court with jurisdiction over the parties in the subject matter. The court can compel arbitration if there's an agreement in compliance with Section 5, unless the court determines that the arbitration should not proceed under Section 12. This section also provides the reasons that a court is required to terminate arbitration. Section 8 requires that the arbitrator to be an attorney or a retired judge, and also they have to be trained in identifying domestic violence and child abuse. If that person's unable or unwilling to act, or if the method for selecting them fails, then the court shall select an arbitrator. Section 9 requires individuals to disclose any fact that is likely to impair or affect the impartiality of the arbitrator or the arbitrator's ability to make a timely award. It also provides remedies if that disclosure is not made. Section 10 provides that a party may be represented by an attorney. They can be accompanied by someone who's not called as a witness, and they can participate to the full extent allowed by law. A party or representative shall not have ex parte communications except to the extent allowed in family law proceedings with a judge. So those same rules would apply. Section 11 provides that before an arbitrator is selected, the court may enter temporary orders. After the arbitrator is selected, the arbitrator may enter temporary orders, or the court may enter them in certain circumstances. Section 12 defines what a protection order issued here would be. If a party is subject to a protection order, the arbitrator shall stay the arbitration and refer the parties to court unless the court makes certain determinations. Section 13 requires an arbitrator to conduct an arbitration appropriately. Each party has a right to be heard, and the section also lists the powers that the arbitrator has. Section 14 provides arbitration hearings do not need to be recorded, but a verbatim recording must be made of any part of an arbitration that concerns child-related disputes. Section 15 requires an arbitrator to make an award and assigned record. The award shall state the reason in which that decision is based. An award determining child-related disputes shall state the reasons on which those are based separately as required by law. An award is not enforceable as a judgment until it's confirmed, and Section 16 allows a party to move the court for an order confirming that award. The court shall confirm the award if the parties agree in a record to the confirmation or the time has expired for making a motion and there's no pending motion. If an award determines child-related disputes, then the court shall confirm if the award on its face complies with Section 15 and other state law that would be applicable to child-related disputes, and it also would be required to be in the best interest of the child. On confirmation, that award is enforceable just like any other judgment. Section 17 allows an arbitrator to correct an award on a motion of a party within 30 days of giving notice of that award if the award has an evidence mathematical miscalculation or mistake. If the award is imperfect in a matter of form that's not affecting the merits, or to clarify the award. So essentially they can just make clerical errors at that point, or corrections to clerical errors at that point. Section 18 provides the method for the court to correct that award. Section 19 establishes reasons the court can vacate an unconfirmed award. And Section 20 provides that if the meaning of a confirmed award is in dispute, then the parties may agree to arbitrate that, or they can then proceed to court. Section 21 requires the court to enter judgment in conformity with their order. The court may order certain records either be redacted or sealed at that time. Section 22 provides that if a party requests modification of an award, the party shall proceed under the dispute resolution method specified in the award or agree to arbitrate or proceed under other state law. Section 23 requires the court to enforce a confirmed award. Section 24 provides the actions that you can appeal. Section 25 provides that an arbitrator is immune from civil liability to the same extent that a judge would be in those circumstances. An arbitrator is not competent to testify and shall not be required to produce records unless it's necessary to determine a claim by the arbitrator against a party or a motion to vacate an award. If a person commences a civil action against an arbitrator and the court determines that the arbitrator is immune from liability, then the court shall award the arbitrator reasonable attorney fees. Section 26 requires consideration be given to the uniformity of laws. Section 27 provides that the act modifies, limits, or supersedes certain parts of the Electronic Signature and Global National Commerce Act. Section 28 applies this act prospectively to arbitration agreements that are made on and after July 1st of 2023. And it also allows the parties to agree in a record to apply this arbitration act to agreements that are entered into prior to July 1, 2023, if they want to. And I can take any questions.
Questions, Representative Carmichael.
Thank you, Mr. Chairman. This legislation seems quite familiar. Have we seen this or something similar to it previously? And if so, what fate did it meet?
Yes. So the moment I got up here, I realized Representative Carmichael is going to ask me this, and I forgot to write it down on my bill brief. So last year, this was House Bill 2496, I think. I remember that. You guys passed it out of committee, but I do not remember if it went across the floor. So I'm going to have to get that information.
I can look that up. The bill number is the key for me. Section 27 of the bill addresses, I believe, a global signature, the Electronic Signatures in Global and National Commerce Act, appearing in 15 U.S.C. Section 7001 at SEC. Do you know anything about that? What does that do? I think that's a new provision, or at least it's not one that I recall.
Mr. Chairman, Representative Carmichael, that section, you'll see that in a lot of uniform acts that come from the Uniform Law Commission, just because there are certain other notice and signature requirements in this bill. So certain, if it's more specific, if there are certain requirements in here, then this act is going to supersede those.
That makes sense. Thank you for your assistance.
To help Natalie, this bill did pass the House last year, 121-0, went to the Senate, was referred to their Judiciary Committee, but didn't have a hearing. So any other questions for Natalie? Thank you, Natalie. Let's see. Let's move on to proponents. First and only up, Larry Root.
Chairman, members of the committee, thank you very much for the opportunity to speak with you today. Natalie did a great job outlining the sections of the act, and I don't intend to go through them all again unless you have a burning desire to hear some of these things. I will maybe underscore a couple things. I'm a full-time mediator and arbitrator. Our firm has a panel of outstanding and well-trained mediators and arbitrators that handle cases both in Kansas and Missouri. And in about 2015, I received a call from the American Bar Association and asked me to sit on a committee of the Uniform Law Commission looking at arbitration of family law cases. I have a background in family law, but I also I've been handling arbitration cases for a number of years. And so I was happy to join the committee that was chaired by two outstanding leaders, Barbara Atwood out of the University of Arizona, and my good friend and colleague, Professor Liddell Rod from Washburn University. And after we had a very excellent committee, individuals scattered from around the country that were knowledgeable of both family and arbitration law. And it was passed by the commission in 2016. Well, we decided to wait. I'm speaking today on behalf of the Kansas Bar Association. The Kansas Bar decided we better wait until we pass the revised Uniform Arbitration Act, which the legislature did in 2019, which provides greater due process protections in arbitration, and then bring this action to the floor, or at least to this committee. And absolutely, as stated, this passed the committee last year. 121 to nothing on the floor, but we did not get a hearing in the Senate. We're hoping this will be a more favorable year for us to get a hearing, and we certainly welcome your support. I think what I'd like to touch on with this, and the reason that people were interested in it, is that the act provides the opportunity for people to pick their arbitrator, somebody who is knowledgeable in family law, might be a retired judge, it might be a law professor, it might be a very skilled practitioner, to pick someone to handle their case quickly and efficiently, to choose the issues that are going to be decided in arbitration. This is all by contract. Determine the timing and the location of the hearing. We can do these in the evening. We can do them on the weekend. We have lots of flexibility as arbitrators to set these cases up and move them efficiently. The parties determine through their agreement how evidence is going to be produced, and particularly confidentiality. Individuals that want to protect information about their assets from their own family or from others, we can set up confidentiality provisions through protective orders to protect that information. The difference between commercial arbitration and family law arbitration is we have protections set up through the commission for families and children, particularly in the area of domestic violence. If there are serious allegations of domestic violence, the proceeding will be suspended. Parties are allowed to bring in advocates that are non-attorney advocates to support their position during the arbitration. There are a number of provisions that if the arbitrator is going to handle parenting time or custody, there needs to be a record, and that record is approved by the court to make sure it meets state standards. And so there's quite a bit different type of system in place for a family law arbitration than commercial arbitration. We think it's a good bill. I would urge your approval. I stand for any questions you might have.
Any questions, committee? Representative Humphreys.
Thank you for being here and for the reminder about this. I just have a few questions about it. So I'm all about arbitration, no issues or anything there. My question is, what do we have now as far as arbitration goes with family law, and what problem are we trying to solve by doing this?
That's a very good question. People right now can agree in writing to have an arbitration of their family law case, but we don't have any procedural protections for them like this act provides in terms of domestic violence or how children are protected in the process and so forth. And so we think it's much better to have a uniform act which contains those procedural protections. But yes, people, and it's generally done now if it's division of assets cases. You know, we're trying to figure out how we're going to break up the debt, who's going to get the house, what are we going to do with the subchapter S corporation. So it's done in that way, very rarely with respect to custody or visitation or anything like that.
So, but I assume you've been arbitrating custody and visitation and all of those things in the past. And I'm just curious what sort of authority or what were you operating under?
If I were asked to do a custody visitation, I probably wouldn't do it as an arbitrator. I might be, until this act is passed, I would not be comfortable personally.
I do it as a mediator, but not an arbitrator.
Yeah.
Interesting. Okay. And then the one that we passed in 2019, you have kind of said, I think twice you used the term commercial arbitration. Would you say what we passed in 2019 was a commercial arbitration act?
No, it was more of a general arbitration act, which was more all-encompassing. It did not exclude family law, for example, or nor did it specifically include it.
So, but you find whatever we pass in 2019 to be inadequate as far as parameters for family law arbitration.
Family law arbitration.
And are there other areas of law that we might need to pass the uniform arbitration law? I mean, so we've got the general one, and now we're doing family. Do you anticipate there's some other area that we're going to have?
I do not anticipate there'll be any additional uniform acts in this area. I think this is all encompassing.
Yeah. Okay. Thank you. Thank you, Mr. Chair.
Representative Smith.
Thank you, Mr. Chair. My only question, I'm over here. My only question on this, you said that your organization also operates in Missouri. How did they compare to what you're suggesting here? Is this taken from them? Do they have anything like this?
Missouri has not taken this action up. What they have done, we've been working with the circuit court in Clay County, Missouri, to do some arbitrations under general Missouri law. They have also passed the revised Uniform Arbitration Act. And so we've been taking a limited number of referrals from the Clay County Circuit Court, Liberty, Missouri. But by and large in Missouri, they have not taken this up, nor have I brought it to the bar's attention. I'm a member of the bar there, but it's not something that I'm spending a lot of time thinking about in Missouri. I live in Kansas.
I understand. Are you aware of any other state that follows a product like you're suggesting here, that's suggested here?
Yes, passed already is Arizona, Hawaii, Montana, and North Dakota. I sent testimony into Pennsylvania last year. What's happened? There's been a delay because of COVID. You know, these uniform acts kind of fell lower on the list of things that were legislative priorities in different states. But yes, I think we'll see a lot more activity now in state government.
I guess my question is more, they've passed it. How long have they been operating under? Is there something to benchmark the success of it?
I would say the states I just mentioned, they've probably had it for the last 5 years or so.
Thank you.
Representative Carmichael.
Thank you, Mr. Chairman. Mr. Root, thank you for being here. Larry Root's one of the preeminent practitioners in this area of the law in Kansas, and I very much appreciate the time and effort you put into these matters.
Check will be in the
mail. Yeah.
Have to wait until session is over.
Yeah, bribes are only accepted after session. That'll be a very valid defense, I'm sure. Seriously, Mr. Root, could you just explain to us initially for a moment, what is the Uniform Law Commission? Because you're the first person we've had in front of us. I think Chairman Patton is perhaps even a member now, but could you tell us just kind of quickly what it is and where these ideas come from?
Absolutely. The Uniform Law Commission was actually begun as a not-for-profit corporation back in, I think, 1892 or some date like that. And what their goal is to have uniformity between state laws to cut down on costs and confusion as we have individuals move from one state to the other or issues arise in one state or the other. And so the Uniform Law Commission, the place you've heard about them the best is the Uniform Commercial Code. They developed that in Kansas. Kansas was one of the first to pick up the Uniform Arbitration Act back in 1955, and then of course, as I mentioned, picked up the revised Uniform Arbitration Act. I think in 19, although I think my testimony says 18. I think it was 19, and these are all volunteers. They've come from all over the country. None of us, as a committee member for them, they don't pay us anything. We fund ourselves to go to these various committee meetings in different locations around the country, and I found lots of some of the better attorneys, and in many states, the chairs of Judiciary Committee are invited to attend, and I suspect that's what's happened in this case. And so we often find individuals that are heavily involved with state law issues on these committees. I was very impressed with the committee I was on. It was my first go around with Uniform Law Commission. I was sort of like you. It's sort of like, what is this? What is this beast? But they've been around for a long time. They have all their bills are up on the website, so you can kind of check and see what they've been working on. They do work on family law issues as well, above and beyond the Family Law Arbitration Act. I think they're a very good organization. I was very impressed with them.
But so that we also understand, states do not have to adopt what the Uniform Law Commission decides.
They do
or if we want to make changes in what they recommend to better fit the circumstance in our state, we're entirely independent. We don't have to follow their recommendations. Is that generally correct?
Absolutely true.
If, with your permission, Mr. Chairman, I'd like to ask a more substantive question. How or when is arbitration triggered? For example, I could contemplate that in a prenuptial agreement, my spouse and I might decide that we don't want to come to court if God forbid we should ever break up again, and put that in our prenuptial agreement. Or perhaps at some point during the course of our marriage, we think, it'd be a good idea to get the lawyers out of this. And so we might want to execute a separate agreement in the event we ever break up. We want binding arbitration, or I assume it could happen perhaps after the filing of a divorce petition. Can you help me know at what stage folks have to invoke the right, and how, if at all, can they revoke that agreement?
Very good question. And Natalie touched on it in her testimony, but how it works is this. Normally, these show up in prenuptial agreements if they're going to be used. But if it deals with children, if we're talking about custody, if we're talking about parenting time, those have to be reaffirmed before the arbitration because that agreement might have been 10 years prior. There may not even been any kids in the marriage 10 years prior. And so the committee decided that we don't care what it says in the prenup, but if we're talking about kids, you need to reaffirm that you want to take that into arbitration. And that is the biggest change in this. Yes, you can, following a divorce, you can certainly, the parties can agree to arbitration. You can certainly agree as the divorce is being filed. At the end of this, we can go into arbitration on various issues. It might be maintenance. It might be division of assets. It might be issues dealing with children. But we're very protective on the committee of children. We want to make sure they were not left out of this. And so your question is spot on because people have to reaffirm those agreements as it relates to children.
And finally, Mr. Chairman, with your leave, I spent a lot of my career dealing with commercial and labor arbitration. And the rule there was generally that you contract for the opinion of the arbitrator, be it right, be it wrong, or be it otherwise. In other words, it's extremely difficult to ever get any review of an arbitrator's decision absent undue influence, fraud, etc. Here, I think we have some safeguards, though, beyond the general rule of arbitration that it is final and binding. Can you refresh my memory and summarize how that works so that in the event the arbitrator goes off on the wrong course, makes terrible decisions, gives the children to the Wizard of Oz, is there anything that can be done?
Yes, that was the other thing that the committee spent a great deal of time on. Is quite a bit different than commercial arbitration. If we're talking again about children, custody or visitation or parental time with the kids, that has to be ultimately approved by the court, and it must meet the standard of state statute. Must be in the best interest of the child. All of those things can, and further, I don't think Natalie mentioned this. Maybe she did, but anything dealing with kids in the arbitration, there must be a record kept. It could be a transcript, it could be a recording, and that needs to be placed in front of the court for final approval before a decision is made, or after the award is offered by the arbitrator.
Any other questions?
I appreciate your questions. Thank you very much, everyone.
Thank you. Committee, you have written proponent testimony that's been emailed out from Professor Elrod, Carrie Behrman, the Uniform Law Commission. Is there anyone else that's here as a proponent? Any neutrals or opponents? Seeing none, I'll close the hearing on House Bill 2017. Committee, now we have a presentation. Heather Cessna is with us here today. She's going to talk to us about the state of public defense in Kansas. Heather's been before us a time or two over the last few years as we've discussed some things that public defense in Kansas, and she asked to have the opportunity to come talk to us, and so she is here today to give us this update. So welcome.
Thank you very much. Thank you, Chairman, for allowing me the opportunity to come and address the committee. And for all of you to spend time. I know yesterday you had a field trip, so this is a good follow-up to that conversation. I'm going to talk a little bit about, just because there are some new faces here that may not be as familiar with what it is that we do and what our agency does. So I was going to talk just briefly with some background information and then go into the big issues that we're facing right now, because I think it's very important for the members of the legislature to understand the crises that we're still very much in the middle of in public defense. So I'll go ahead and start the presentation. First, for those of you who don't know that much about about our agency. I'll give you some basic information. Obviously, since 1963, when in Gideon versus Wainwright, the United States Supreme Court held that under the 6th and 14th Amendments that the states have an obligation to provide indigent defense counsel to clients who can't afford to hire their own attorneys. The state of Kansas has been attempting to provide counsel in criminal cases. Since 1982, we've done that in adult felony level cases through the Board of Indigent Defense Services, which is where I am the executive director. I became the executive director in October of 2019. So this is, I'm a few legislative sessions in, but certainly our board definitely predates me. Most people don't realize how big of an impact BIDS has on our criminal judicial system. Fully 85% of all adult felony level cases in Kansas are criminal cases, are charged against men and women who are too impoverished to afford their own defense attorney. And once found indigent by their presiding judge, BIDS provides all of those counsel for those clients in those cases. So in fiscal year 2022, that was approximately 24,609 cases in Kansas. We provide that counsel through two sides of our system. One is our public defender offices. Those are our direct employees of our agency. We have public defender's offices in a handful of communities. So we have 11 trial offices in Olathe, Wichita, Topeka, Chanute, Independence, Hutchinson, Garden City, and Junction City, and Salina. We have an appellate office that's located in Topeka that covers the entire state, and 5 capital death penalty offices that are located between Wichita and Topeka and cover everything from trial level death penalty cases all the way up through appeals to capital habeas cases. And we also have our administrative office that's also located here in Topeka. And the other side of our program is our assigned counsel program, and that utilizes our local private defense counsel who agree to serve on panels and take appointments in cases. Each judicial district in Kansas is required to have a local appointments counsel and under our regulations. And the hourly rate that we currently have by statute is $80 an hour for those appointed attorneys, which is ridiculously low. Thanks to the investments from the governor's budget recommendations and the legislature over the last few years, we've been able to raise the rate that we are paying those assigned counsel on an hourly basis from 80 to 100 and then from 100 to 120. So we're actually currently paying $120 an hour, but that is through a special budget proviso that runs out at the end of this fiscal year on June 30th. And so we are pursuing efforts to get that hourly rate put into our statute because at this point, I don't think we'll have many people left on our panel at $80 an hour if we revert back to that original statutory rate. At even $120 an hour, that is well below almost half of what the going rate for defense services is in Kansas for private attorneys, for paid hired private counsel, and almost $40 an hour below the federal appointment rate for their appointed attorneys. Now that you sort of have a better picture of the volume of cases that we cover and sort of the outsized role that our cases play in the criminal justice system, I think that's important to help you have a better understanding of why the current crisis that we have is so concerning. Simply put, Kansas does not have currently enough experienced, qualified criminal defense counsel to meet the volume of cases that are currently being charged by local prosecutors across the state. This severe shortage of counsel does manifest itself in several ways. First, our lack of sufficient staffing in our public defender offices in fiscal year 2022 resulted in 8 out of 11 of our trial level public defender offices substantially exceeding national caseloads standards for public defenders. Those standards require that attorneys handle no more than 150 felonies per attorney per year. And those are old 1973 standards. And we have new standards that are supposed to be coming out relatively shortly that will probably change that calculus, but it's not probably going to get better than In fiscal year 2022, 8 of our public defender offices did exceed those caseloads because of a combination of case volumes, but also because of turnover and staffing issues in the office. Those few offices that did not exceed those national standards were only able to keep their caseloads under control by being closed or temporarily refusing cases for over 50% of the year in order to maintain ethical caseload limits. The caseloads and lack of staffing is so acute in fiscal year 2022 that our active trial level public defenders only had on average 11 hours per attorney per case to work their cases. This includes cases as level as like probation violations, all the way up to cases like off-grid premeditated murder cases. To give you some perspective on just how insufficient that 11 hours is, there have been national public defender studies from different jurisdictions all across the United States that looked at public defender caseloads. And those public defender caseload studies have indicated fairly unanimously that for low-level cases, attorneys should be spending a minimum of around 20 hours per case on low-level cases to meet the minimal constitutional standard of reasonably effective assistance of counsel. And for high-level cases like off-grid murders and things like that, between 200 and 300 hours per case for those high severity level cases. Obviously, 11 hours is less than that, and pretty badly. When our public defender offices can't ethically staff their caseloads because of a lack of staffing or because of turnover, or if we have a jurisdiction that doesn't have a public defender's office, then those cases flow to either our contract counsel or our assigned counsel panel appointed attorneys. In fiscal year 2022, we had such a large number of high volume counties and rural jurisdictions that suffered from such severe shortages of local appointed counsel that BIDS as a organization had to assist often multiple times with rebuilding those jurisdictions panelists and recruiting counsel from across the state to handle those cases. Those counties that needed substantial and frequent assistance include counties such as Crawford, Labette, Cherokee, Johnson, Douglas, Shawnee, Sedgwick, Geary, Riley, and Saline counties, among many others. As you know from your work here, those are highly populated counties with a lot of cases. So that is a lot of shortages. As a state, we're struggling to live up to our constitutional obligation under the Sixth Amendment to provide counsel on every adult felony level case that qualifies. Our local counsel are overwhelmed with caseloads that are in excess of their national standards and potentially violate professional rules of ethics. And most importantly, clients and judges alike are very frustrated with the lack of assistance that they're receiving on these issues and how that's playing out day to day in their courtrooms. There are contributing factors to this crisis, and I felt like it was important to talk about those because there are sort of a multitude of things that are contributing to this. First, in fiscal year 2022, BIDS lost 1 out of every 5 public defenders due specifically to low pay. Specifically, BIDS was at the time unable to compete with local prosecutors' offices who offered substantially higher pay for experienced attorneys than we could. Obviously, losing experienced attorneys and staff is absolutely devastating to us because it takes a significant amount of time and training and effort to take somebody who's essentially fresh out of law school or brand new to the concept of public defense if they're a staff person, and to train them up to be able to handle, significant caseloads and high-level cases. So that turnover is devastating. And that came on the back of many years of similarly bad turnover. I think in 2019, right before I came into this position, we lost 1 out of every 4 public defenders that year. So when you look at this as part of that compounding problem, it's particularly difficult. The good news here is that with the substantial investment from the legislature last year, we were able to implement a pay scale adjustment for pay parity with prosecutors. It didn't quite get us fully to pay parity with prosecutors, but it did have a substantial and important impact on our turnover rates. The difference between June 30th with our prior pay and July 1st this past fiscal year was like night and day. We were suffering from high turnover. We were having difficulty filling positions. Our new pay implementation went into effect in July. We are now, we're not losing people because of low pay anymore. And we're to the point where we're now actually running out of vacant positions to fill at this point because we're retaining people and we're able to recruit people into those positions. So while a lot of my presentation is a lot of doom and gloom, I do want to make sure to highlight the important impact that the investments that the legislature made in our agency last year has had. Unfortunately, that is one piece of the puzzle that we need in order to solve these ongoing issues. So our turnover rate has definitely gotten better. However, also contributing to this crisis is the fact that we do have an aging population of attorneys in the state who are retiring in increasing numbers and who are simply not being replaced with the same volume of new graduates out of our local law schools in this jurisdiction. This is particularly problematic in our more rural communities because even when we do have new graduates coming out and going into criminal defense, they are not necessarily moving back to a lot of these rural communities. And so we have such a bad shortage of rural counsel that the Kansas Supreme Court has started their task force to look at this problem, which we are sitting on, in order to try to come up with some possible solutions to work on those issues. What this has meant for us is that we as a board are being approached by a lot of local judges who have been asking us to consider establishing public defenders' offices in their jurisdictions because of the lack of counsel. So places like Crawford, Labette, and Cherokee counties in the 11th Judicial District, where we haven't traditionally had a public defender's office, have such a shortage of local counsel that is so severe and with no replacement counsel in sight that they asked us to review the possibility of a public defender's office. Our agency did that this year, held a public hearing, went through that process. We actually have funding for that request included in our budget for this year because of those counsel shortages. Another contributing factor to this crisis is our lack of staffing in the public defender's offices. The truth is that I can't force people to go into private practice and specialize in criminal defense and open up firms, whether it's in Johnson County or out in near Garden City or Liberal. But I can hire public defenders if I have the positions and the competitive salaries to be able to draw those candidates here. We do seem to have a good handle on the piece of the competitive salaries. I think we're going to have to keep up with that year to year to make sure that we're not falling behind now that we've kind of made up some of that distance. But we are now lacking the actual FTEs to be able to fill in some of these areas to meet our caseloads. We currently estimate that we need, based on those 1973 caseload standards, we're estimating that we need approximately 262 more FTEs across our current public defender offices in order to staff our current caseloads and to make a significant impact on the overloading of our panels in the areas where we have public defender offices. Our board decided to split that request into two pieces. So the first half of that request is actually included in our budget this year for fiscal year 2024 for $13 million and 131 FTE positions. Finally, there have been a couple other specific factors that have added to our crisis and made it particularly acute over the last couple of years specifically. First, the backlog of COVID cases that, came into play because of the court slowdown in 2020 that have been working their way through the system. That's definitely added some pressure on our panels and our public defender's offices. Compounding that backlog is actually the tolling of the speedy trial deadline. We have had some impact with that in various jurisdictions. While some jurisdictions have been very good about using the 2-year tolling that's currently in place for statutory speedy trial to work through those backlogs and those caseloads, not every jurisdiction has been good about that. And so what we're dealing with is we're getting reports from our council that there are cases that are stalling out in jurisdictions and they're unable to move cases, which then prohibits their ability to take more cases when those cases aren't being moved. A return to the pre-COVID statutory speedy trial deadline would definitely help both parties to come to the table in a timely manner for those negotiations to happen. And it really is negotiations that we're talking about, since 98% of all criminal cases end in plea negotiations as opposed to jury trials. Again, because 85% of our adult felony cases require appointed counsel, these problems that we have in our agency have a huge impact on the rest of the Kansas judicial system, and it's quickly becoming untenable. At this point, without some desperately needed assistance, it really is only a matter of time before our critical shortages become so problematic that our indigent defense system will have to consider increasingly drastic and constitutionally problematic options in order to deal with these issues. We only have so many tools in our toolbox, and when those effectiveness of those tools are no longer working, we don't have a lot of options left. But we do have a chance to act quickly and to decisively address these issues in order to avoid those more dire consequences. So to that end, our board of the last 2-3 years has been taking a very practical approach to attempting to alleviate and address this crisis. We've focused on lowering our turnover rate by implementing internal caseload controls through the implementation of a weighted caseload system within our public defender's offices so that we weren't losing people because of our high caseloads. And then we also obviously advocated and implemented the significant pay scale restructuring that the legislature and the governor funded last year. And that pay parity, or closer to pay parity with local prosecutors, has definitely allowed us to increase our retention. We've also carefully assessed those national caseload standards so that we could spec out essentially what we needed as far as our additional staffing in order to not just solve our caseload problems internally in our offices, but also to help impact those panels that are overloaded in many of these jurisdictions. And so we definitely have done that with the eye towards making sure that we're providing everyone with the appropriate staffing that they need in order to provide reasonably effective assistance of counsel to our clients. Over the last few years, we've also requested a significant number of staffing to try to address those caseloads. Over the last 3 years, we have received 44 new FTE positions, which was very helpful and was an important impact, but it hasn't been enough to stem the tide of the volume of cases that we're talking about. And so that's why these additional FTEs are necessary. We've also embarked on a project to conduct a careful review of jurisdictions that are currently underserved and who have asked us for assistance so that we can consider where it's appropriate to strategically place new public defender's offices in jurisdictions where they can have the greatest impact on our local judicial district needs and on the client's quality of representation. Once identified, we have a whole process that we have to go through. We have to have public hearings. The issue is debated amongst our board members. We provide them a lot of data and information as they're going through making that decision. We have 2 of those requests coming through as part of our budget this year that have been entirely through that process. Similarly, we've continued to advocate for better support for our assigned counsel so that our attorneys and contractors have sufficient pay. to be able to take higher numbers of BITS cases. I mean, obviously at $80 an hour, you can only take so many of those before you start losing your shirt. And so by increasing those rates of pay, that definitely has helped us maintain the people on our current panels and add additional attorneys to our panels. The problem is we just literally don't have enough people available to take those cases out there right now. Finally, we've also begun working with local jurisdictions that are interested in some of those larger, like criminal justice reform and local policy and procedure changes, so that we can help address some of the most acute caseload issues and help keep our criminal legal system running as best as we can while still protecting our clients' rights. So there's some specific initiatives we've worked with individual counties. If they've got an idea that they want to implement, we've worked with the judges and the district attorneys and the local defense counsel to try to facilitate those processes. So we're taking a very active approach to this. I was going to go through, although our budget doesn't come through your committee, I was going to run through, because as members, you're going to see it eventually, just what specific requests go along with those bigger efforts. So this year we did submit a significant request for increased funding for 2024. That includes $600,000 for the next step in our employee pay plan. This funding, or the governor's suggested state employee pay raise, would be necessary for our salary progress, so that we don't stall out and backslide into some of those retention issues that we were having over low pay and lack of parity with prosecutors. We also asked for $13.1 million to fund those additional 131 needed FTEs for our current public defender's offices. We asked for $700,000 to fund anticipated capital litigation costs. This is actually to fund a shortage that we're anticipating in our capital litigation costs because of the number of additional capital cases that are being prosecuted in the state. So this is not the total funding for our capital. That's just what we anticipated we were going to be short in 2024. We also asked for $3.7 million to fund the establishment of 2 additional public defender's offices and an additional 30 FTEs on top of our other FTE requests to staff those offices to strategically address needs in jurisdictions that have been underserved and have been through our full review process. We also asked for $785,000 in infrastructure support that covers additionally needed lease space, software licensing, and training funds for our public defenders and our assigned counsel, and a $3.6 million request for the third step in our 3 steps effort to raise our assigned counsel rate. Originally, the proposal was to go from 80 to 100, 100 to 120, and 120 to 140 to get closer to that federal appointed counsel rate in order to draw in as many attorneys to our appointments list as we can. So this is to fund that last step from 120 to 140. Unfortunately, in spite of significant projected budget surplus and in spite of the clear crisis that's happening in our defense system, the governor's recent budget recommendations for our agency did not include any new funding for public defenders or for public defender offices, and did not recommend increasing our assigned counsel rate, that additional last step up to the $140 an hour. Obviously, this is problematic because without some desperately needed assistance, our shortage of attorneys is only going to continue to get worse. So we're definitely going to be talking a lot to the legislature about how we can hopefully supplement our needs this year so that we're not sliding into a deeper part of this crisis. Obviously, while these investments are significant, they are necessary for us to be able to fulfill our constitutional requirements in the United States Constitution. But also, investing in public defense can save taxpayer money. I did want to tell just a little bit of a story that recently came to my attention just to kind of illustrate what I'm talking about. One of our appellate public defenders recently posted about some success that our appellate defender office had had over the last few months. Specifically since October 7th of 2022, so just in the last 4 months, and just between 3 of their clients, that office was able to save those clients a total of 284 months in prison. That's almost 23.66 years. And that came from a combination of correcting inaccurate and inappropriate criminal history scores, and some challenging of some of their convictions after trial. The interesting part of that for the legislature's purposes, obviously in addition to what that did for those clients, is that it saved the state of Kansas, just those 3 clients, and just in 4 months, almost $900,000 in KDOC costs because of the lack of needing to take up that bed space for the remainder of those sentences. And like I said, just from one public defender's office in 4 months with just 3 clients. I mean, when you start looking at the benefits that you can have from sufficiently investing in public defender's offices in our public defender program with our assigned counsel, in the long run, that ends up actually saving us money in future downhill costs. So in order for our criminal justice system to work, we need all 3 pieces of the system working: the judges, the prosecutors, and the defense. And right now, our defense system is in dire need of assistance because without, there is no justice without the public defense system. I very much appreciate your time, and I am more than happy to stand for any questions that you might have about the details of what we're doing or about the issues that we're experiencing. Thank you.
Questions, committee? Representative Humphreys.
Thank you so much. So with the temporary, but hopefully not, pay raise of 120 per hour. So just can you give us an example of about how many hours they work? Like what's an annual salary?
The $120 an hour goes to our assigned counsel. So those are our private appointed attorneys.
Okay.
So our private appointed attorneys, I mean, their total salary is definitely going to depend on how many cases they're taking and if they're
They do other things too. I mean, they would have other cases that aren't with you all, or they're full time with you.
Most of them take other pay cases.
Mm-hmm.
So, I mean, there's probably a handful that do primarily take bids cases, but most of them take other private clients.
So are they contracted with you, or they get benefits from, or, how does that work?
So we actually do have some contract attorneys that we pay specific rates for to take like certain kinds of cases or to help try to control costs in areas where we have a lot of reliance on the panel. Neither the contractors nor the regular appointed attorneys get any benefits from the state of Kansas. They're essentially independent in that way. They bill us for their time and we just pay their hourly rate and their expenses and things like that. We do also pay for, in those cases, just like we do with our public defender's office cases, we pay for experts when they need like investigators or they need some kind of psychological expert or something for a case. So we do pay for those costs as well, but that's not included in their hourly rate.
And so the public defender, they are employees of bids.
Yes.
Yeah. Okay. And that would be just, I mean, you don't have to go into details, but if someone just was hired out of law school, or maybe they wanted to change, their area of law that they wanted to work in, what would be like a starting sort of salary?
So our starting salary for people like fresh out of law school, depending on if they're starting in a more rural area or a more urban area, is about $62,500 to $65,000.
Mm-hmm.
I can tell you, I mean, our top paid, because it's public record, our top paid public defenders who are, 25, 30 years worth of experience, death qualified, heads of their offices, their top paid salary right now is $130,000, which is still far below most prosecutors' offices.
Yeah. Okay, great. Good info. Thank you. Appreciate it.
Thanks.
Representative Lewis.
Thank you, Mr. Chairman. I'm interested in seeing if we can establish a benchmark, by which I mean, can you point to a time in the past, whether it's 10 years or 20 years ago, where you think that the public defender's office was adequately staffed and had adequate resources?
No. Okay. It has never, and I will say this, I do think that there was a historically a lack of our agency and under prior administrations coming to the legislature and articulating fully the problem that we were having. I think the public defender's offices themselves were primarily bearing the burden of that problem by essentially being expected to take what I would say were clearly unethically high caseloads, because that's just what you did as a public defender. There was kind of this mentality like in the 80s and 90s that public defenders are overworked and underpaid, and that's just what it is. I think we sort of wised up to the fact that we don't have special ethics rules that accept out public defenders from having to comply with the having reasonable caseloads and being able to dedicate the appropriate amount of time. And that's one of the reasons why, not just here in Kansas, but nationally, the caseload question and how to count caseloads, what are appropriate caseload standards, has been really at the forefront of a lot of litigation in almost every state that's currently under suit in other jurisdictions, because those caseloads were problematic. And so, we obviously don't have that litigation here. And so, but clearly, if we had continued down the path that we were going down, I think that would have been particularly problematic or particularly likely. So by trying to focus on our caseloads and working on those issues proactively, coming to the legislature over the last couple of years, asking for the things that we need in order to address those things, we're hoping that we can be proactive and address this without having to be told to. Yeah.
Follow up. Well, first of all, I just wanted to say thank you. I'm from Finney County, Garden City, and I've talked with private attorneys, public defenders, prosecutors, and the way you're describing the problem is accurate from our perspective. And we also have a big problem with, because we're in the rural area and we're not getting the new lawyers in. On that point, are the law schools in Kansas not putting out enough lawyers, or is it that the lawyers they're putting out are deciding not to go into criminal defense work and or going to rural areas?
I think it's a combination of both. The law schools are definitely graduating fewer candidates than they were like 10 years ago. I also think that they would have to be graduating a significantly higher amount of new attorneys to replace the number of attorneys that we have essentially, retiring and aging out and no longer practicing, because there is it's kind of a generational thing going on too. I also think that, because it is very rare for somebody to graduate from law school without a hefty amount of student debt. And so the lower salaries that we have and have had traditionally for those attorneys really makes oftentimes being, even if they have an interest in public interest law, whether it's for us or like Kansas Legal Services or something like that, it makes it prohibitively difficult for you to be able to go into that kind of practice and be able to do basic things like get married and have kids and buy a house and pay for daycare and all of those things on top of your student loan payments. We do have federal student loan payments for public service, but it takes a long period of time to qualify for that. And while it is certainly worth it, it's hard for a lot of our attorneys to stay with the system that long. That's one of the reasons why I do think that our pay scale, even though our starting salary prior to the implementation of our pay scale was around $55,000. So we went up, almost $10,000 for our starting salary. So that was huge. But the other thing our salary changes did was it widened the space between those people fresh out of law school and the people who have 30 plus years of experience, so that there was more room to grow. Because when you're, 10 years into practice and you're only making $7,000 more than you were as a brand new law student, you start looking elsewhere. That's the reality. And so that has definitely helped with that too. In fact, actually, since you're from Garden City, I will say we actually just were able to recruit through a national recruiting event for a brand new law student who's going to be starting out in Garden City this summer after taking the bar. So I think there are candidates out there, but we're definitely having to do a lot more national recruiting, and we have to be able to give them a salary that will allow them to live while they're here doing that work.
One more? So do you have any statistics going back once again, I don't know, 5, 10, 20 years, on the number of times that appellate courts have found that the work of public defenders, or for that matter, the private lawyers doing the work, were ineffective?
I don't have those statistics off the top of my head. I will say that those kinds of statistics are, on the one hand, they can be helpful, but on the other hand, it is so difficult to meet the standard of ineffective assistance of counsel that it's not necessarily accurate that, like, if you didn't get found ineffective, that your representation wasn't somehow problematic. And that's because there are a lot of rules, like, for instance, you can't file an ineffective assistance of counsel claim under 60-1507 unless you're incarcerated. So if your sentence runs, you're not ever, and you don't have a chance to do it ahead of time because your appeal took 5 years or something, you don't get to file that. So it is a little difficult to extrapolate from those details, but certainly I can follow up and provide you with some of those with that caveat.
I appreciate that very much. Yeah. I understand. Courts typically will protect the lawyers in those cases, and especially in the criminal defense area. I understand that. Do you have statistics on the number of your clients, that is to say, indigent defendants, over the years, how those numbers, I assume they've grown?
Yes. So I'm trying to think back. I can probably follow up with the more specific standards, or the more specific numbers. But I know over the course of the last 5 years, we've probably increased our total number of cases that we have in bids by about 10 to 15,000. And that's, that's also not. It's also the time that it takes to do those cases has also increased significantly because of other factors, such as the increased use of the body cameras and the amount of footage that you have to be able to go through. So even if the number of cases had stayed the same, I think the amount of time that you have to spend actually being able to investigate and defend those cases has certainly increased significantly over the last 10 years. So it's a combination of both an increase in the amount of work that goes into those cases by, because of the kind of evidence that we have, in addition to actual case numbers going up.
Thank you very much.
Representative Heiberger.
Mr. Chair, with regards to your contract attorneys, are there caps on the number of hours billed for particular types of cases, either formally or informally? And the reason I ask is most private solo practitioners I know don't bill for all their hours, or even close to all their hours. So $120 an hour really isn't $120 an hour.
Yes. So both for some of our contractors and for our actual appointed counsel, we have reasonable rates of compensation caps. There is some ability to get exceptional orders above that under our regs. One of our problems historically has been that those caps have been, even though they're called reasonable rates of compensation, when you actually calculate out the number of hours associated with those, are patently unreasonable. So we're actually working our way through the rules and regs process to work on amending those as well, because that has been an issue. So hopefully we will, and we've done that. We've crafted those corrections that we're going through that process now on to match the caseload standards that are coming out now, talking about the amount of hours that should be spent on certain levels of cases. So we'll get to a place where we're better matching what actual case cap should be, hopefully, assuming we get through that process. Yeah.
Representative Carmichael.
Thank you, Mr. Chairman. Two things. Hopefully I'll be brief. First, just by way of reference, I practice law in Wichita, Kansas. Two of the lawyers in our office accept federal appointments at $160 an hour. And quite frankly, one of them's got 40 years of experience. And the reason she does it is a commitment to justice. And quite frankly, she likes to try jury cases for some crazy reason at this age. She still does. But the rest of the time, we charge between $300 and $350 an hour.
Mm-hmm.
And that 120 or 160, or in your case, $120 an hour, it's not like the lawyer puts it in their pocket, because we have rent, we have secretaries, we have malpractice insurance, we have general liability insurance. I could go on and on and on. And so at some point, it does become financially prohibitive for people in my office to help bids. And I wish we could change that somehow. You know, any suggestion? Yeah.
Yeah. Well, and I like, actually, Wichita is a good example of one of the places where I think our need for a large chunk of the bar to have to essentially come in and do that out of the kindness of their heart and take a loss on a lot of those hours would be severely decreased if our public defender's offices could be fully staffed, because our public defender's offices traditionally, historically, have been more cost efficient, just literally because of the ability to handle all of that stuff in-house. You've got in-house investigators, in-house legal assistants, in-house administrative assistants that handle a lot of the stuff that, you know, we may be paying separately for an investigator for an assign for one of our appointed counsel outside of even the $120 an hour rate. So the that is a perfect example of, our $120 an hour rate or $140 an hour rate wouldn't be as problematic as it is if we had sufficient staffing in our public defender's office, so that the amount of cases that are going to the panel was not so overwhelming.
And then, for whatever it's worth, for routine defense cases, you have not only a public defender, but you also have the conflicts office, which handles defense in multiple defendant cases where I guess there's conflict of interest. So you fund that separate office. And then, of course, you have the capital defender office, as well as, I assume, appellate defender office too.
Yeah, our appellate defender office is in Topeka, but does cover Wichita. And yeah, in Wichita and Topeka both, we have a main public defender's office, a conflicts public defender's office, a contract attorney, or set of contract attorneys, and then that all is before the cases get to the appointed panel. And even that, we are overwhelming the appointed panel because we've gone through all of those layers. And that's in both.
You can't hire one lawyer to represent two defendants whose defenses are in conflict with one another, i.e. the he did it, no, he did it defense. We have not talked, though, about the capital defender unit and the cost of defense of capital cases, and in particular, not only the guilt phase, but also the mitigation phase. And as you may know, a good friend of mine has worked for you all for a long time, and that's what he does. But do you have any handle on how much we're paying, not only for capital defense cases, but also for the mitigation phase, which we don't have in most other trials, as well as the eventual appeals? Do we have any handle on how much the death penalty is costing us from the standpoint of your agency, without even talking about prosecutors?
So our projected costs, or our budget for the death penalty for 2024 is around $5 million. And there are roughly 26 capital cases in Kansas. So that's almost 12% of our budget for less than 1% of our cases. I don't have the specific breakdown on the mitigation versus the rest of it. I mean, obviously some portion of that would still, if those cases were not charged capitally, would still be, would still cost us some money, but it certainly wouldn't cost as much. One of the other problems that we have right now in our capital area is that we literally do not have enough capital qualified attorneys in Kansas. And so we're currently having to contract with attorneys from Oklahoma, Missouri, and Colorado in order to come in, which of course greatly increases the cost that we're having to pay for those travel, to be able to come see their client, to be able to come to court and all that kind of stuff, so that we can do our best to comply with the ABA guidelines that require a certain level of counsel to be able to represent those capital cases. And even that we're oftentimes not being able to fully comply with for both counsel that are assigned to those cases.
Representative Humphreys.
Thank you. I think it's a quick question. I just want to go back really quick to, you had mentioned the forgiveness of debt. So can you, if you could explain that a little bit better to us, and like if they don't serve the whole, whatever, 10 years, do they get it partially forgiven? And how many of your attorneys are taking advantage of that? I know when I was in law school, that was a big consideration for people that might want to go into the public defender's office.
Yes. I will try to answer that question, although I will tell you that program actually came after I was already well out of law school and had gone through my own debt, so and paid off my debt. So I'm not as familiar with that as probably some of our other attorneys. For example, our general counsel, Mr. Barrett's here, and he actually has used that program. But I can kind of tell you, and then if he wants to maybe jump in, I'll give him a second. But it's the debt loan repayment is a federal public service payment. So prosecutors, public defenders, they're both eligible for that. It takes roughly 10 years, is that right, to be able to qualify for that. And you have to follow the rules by the letter of the law in order to be able to qualify for those payments, in order to get that debt released. So, we do have a chunk of public defenders who, because they started their careers with us like 10 years ago, have been able to pay off their debts with that. But it's definitely hard to keep people in the system for that long. Do you want to talk just briefly about how that works, or is that?
I think that we will check out.
Our general counsel.
Sure. Good evening, ladies and gentlemen. Ms. Eston's description of that program is largely accurate. It's 10 years worth of payments, it's 120 individual payments while a person is employed in most public sector jobs. So a prosecutor, a defense attorney that's working with a public defense system, something involved with the legislature. There's a number of different categories that would qualify for that, but it does necessitate 120 payments. They don't have to necessarily be consecutive, but they do all have to be within that group. And there are a number of hoops that one has to jump through to qualify for that. Some of that was alleviated with some work by the federal government over the last 18 months, but you have an equal number right now based on just anecdotal evidence of people who have had that debt repaid at the end of 10 years, as you do people who now owe more money than they did when they took out their loans originally after going into service in a public sector job and not being able to make enough money.
So, and then my question about partial payment, they're making 120 payments to the maker of the loan, right?
Yes.
And so are they making them as you go along? And then if you stay 5 years, then you've gotten 5 years worth of payments?
You could then pick up at a 5-year mark at a different public service job, but it doesn't reduce.
What if you don't?
Then that 5 years is basically wasted in terms of that repayment.
That's what my question was. Yeah. Okay. But I do think it is a benefit that we shouldn't downplay, that it's to get those debts paid off is really, it's a positive.
It definitely is a positive. And actually, I would like to see, one of our board members had asked us to look previously, and we didn't have a chance to really flesh it out, because there have been some proposals in other states to do something like that on a state level in order to keep people in their specific systems. Because one of the problems like we have is you can qualify for those loan payments as either a prosecutor or a public defender. So like when we had people who had 5 years of service in our public defender agency, but then the prosecutor's office is able to pay them more money, they were still able to go across the street to the prosecutor's office and still be able to participate in that loan repayment program. So it wasn't necessarily as much of an incentive to stay with us as it could have been as maybe a state, local program would be. So I do think that's something that we're going to talk about, maybe in future years.
Worth it. Thank you. Thank you, Mr. Chairman.
Mm-hmm.
Other questions? Very good. Thank you for coming, Heather. I appreciate that. She gives great input when we have bills come before us, either officially or she'll email or she tweets. Follow her on Twitter. Anyway, I appreciate the update, and anything we can do to help, I think we're willing to do so. The status of your legislation to raise the hourly rate.
Yes.
Am I working on that, or is someone else working on that?
I've been trading emails with Mr. Anderson. So he's actually
Keep me
our
posted.
chair. So hopefully I'll be meeting with him next week and get that moving.
Sounds good.
Yeah.
That's it, committee. No meeting tomorrow. We do have some meetings next week. We're gonna work some bills at some point next week. Usually I'll give those to you early in the week, but I might as well give you where I think we're at now. 2015, 16, 17, and 18. I'm pretty sure we'll have up at some point next week. The calendar or the agenda has us just working bills on Thursday. I may visit with staff to see if Wednesday's an option, because we were supposed to have a presentation on Wednesday, so we just freed up 25 minutes because they're now not going to present. So we might be able to work these 4 bills on Wednesday and not meet on Thursday. So we'll see. So stay tuned, but I'm pretty sure we'll get to those 4 bills and maybe more, but we'll see. So that's it. Have a great weekend. We're adjourned.